make regulations relating to transaction limits contemplated in section 19.3b, norms and standards for coordination of the provincial and local gender-based violence and femicide structures, and C, any other matter which it is necessary or expedient for the proper implementation and administration of this act. General comments. The National Council is crucial to the rollout of the NSP, and for as long as the council structure are not established, the NSP gender-based violence remains as ideal with potential, but not quite materializing or achieving its objectives. It is therefore important that the National Council is established post-haste. Having said so, the council cannot be established on vague terms, and the bill cannot afford loosely defined structures, omit to describe the portfolios of key role players and firmly established accountability mechanisms. We therefore submit the bill needs to be reviewed to provide clearer and firmer accountability measures through the definition of key structures, beginning with the council itself. I think it is important to go back to the fact that we have indicated where we talk about the regulations in this structure, that in this response, that norms and standards will be established, but also any other matter which it is necessary or expedient for the proper implementation and administration of this act, means that we'll be able to address all the issues that have been raised. However, also provinces have indicated that we can't always be creating new structures. There are structures that are already existing and working in the provinces. So what we need to do is to absorb them so that the council can be able to work with them. And that has already been incorporated in the bill. The next one. Question 2, Voice It in Action and South African Youth Workers Association. Their question was that first page, there should be a date and stamp reflected, and also showing the latest version on the document, including where it can be accessed with a link following parliamentary monitoring group. That information can be provided on the explanatory note as advertised, but not in the bill itself. That is our response. Clause 4, clause 4 should provide clear description of where to find unlisted words that are not in the document, such as objects as defined in the dictionary. If the word is not defined in the bill, that was our response, it is acceptable to use the definition of the Dictionary and Interpretation Act 1957. The next one is objects, facilitate the development of the monitoring and evaluation framework that will be used to track the implementation of the NSP on gender-based violence and femicide, as is further stipulated under functions of the council. Clause 5.1a 3 provides that in order to achieve the purposes of this act, the council must develop an action plan not later than 6 months after its establishment for the implementation of the national strategy addressing gender-based violence and femicide, which must coordinate the monitoring and evaluation of the implementation of the national strategy addressing gender-based violence and femicide. Clause 6 refers to the number of board members, which are 15 in total. However, the document is silent on the importance of equal representation in terms of gender and youth participation. Therefore, we recommend that there should be 45% women and 45% men, with 10% allocated to LGBTQI persons, cognizant that persons with disabilities are included within this breakdown. For example, civil society and all that. The bill cannot prescribe gender, race, sexual orientation, etc., lest it is declared unconstitutional for discriminating against other groups of persons. However, the bill provides for a nomination process that is inclusive, fair, and transparent. Clause 6.3 provides that the president must, whenever necessary to appoint members of the board, referred to in subsection 1A, make an appointment from a list of persons recommended by the National Assembly by way of resolution with a supporting vote of the majority. I had already read clause 6. The appointment of board members clause is developed in line with the National Strategic Plan on Gender-Based Violence and Femicide, which is the founding document of the bill. However, clause 6.9 provides that the minister may co-opt any person at the request of the board to assist the board with regard to its functions in order to A, advise and provide the necessary expertise in their specific field, represent a relevant stakeholder, whereas clause 6, subsection 10 provides that a person co-opted in terms of subsection 9 may take part in the proceedings of the board or its committee, but is not entitled to vote. This clause seeks to ensure that all relevant stakeholders participate in the council by providing expert advice to the board or represent a relevant stakeholder when it is necessary. Clause 9. I'm going to run because I'm really worried that the minister might leave before we finish. Under terms of office and section 9, under vacancies, we recommend that the process of appointing council board members should consider appointing additional shadow council members, in particular, the youth, for purposes of subsection 1, exposure to serving in the council, subsection 2, upskilling, and subsection 3, quick closing the gap in case of an open vacant position in council as articulated in subsection 7 and 11. The proposed shadow shall not have voting powers outside the 15 members of the council. I think this, I've just responded to that because we said the minister may co-opt any person. That is the last response that we had given. The minister may co-opt any person at the request of the board to assist the board with this regard. So I believe that that section responds to this section, to this question. Section 11, subsection 1B, 1C, 1D, and 1E. Board members' terms of office which can be ended for reasons listed in this subsection above. We recommend that the members replaced should not be disqualified to serve a full 2 terms after the replacement period. We believe that this could be an advantage for the member to learn more. Clause 9 provides that subject to sections 11 and 12, a member holds office for a period not exceeding 3 years, but is eligible for reappointment for only 1 additional term, not exceeding 3 years, and is also eligible for extension of the office for a period not exceeding 6 months. However, what the person is asking that the replacement must serve the full 2 terms, that will be the prerogative of Parliament, because Parliament is the one that appoints the members. Section 13 Board meetings, we recommend that during the first year of the council meetings, there should be 5 meetings in total. That will include the first meeting of the board with the Minister of Women, Youth and Persons with Disabilities, and 4 meetings being the ordinary board meetings to maximize the council's output. Clause 13 provides that the board must meet at least 4 times a year. At least means that it can be more than that. Section 15, subsection 6E should be added in the Act to clearly articulate the need for the CEO to be given the opportunity to improve performance and outputs through capacity development, personal and institutional development over a specified period of time. This information should form part of the CEO's performance contract. Further, in the CEO's employment contract, issues of disciplinary measures that the board will execute should the CEO be found in contravention of the Act. As suggested, this information could be included in the CEO performance agreement and cannot be legislated. The next, section 21, refers to the use of the name of the council. Section 3 reads as follows: a person who contravenes subsection 1 or 2 is guilty of an offense and is liable on conviction to a fine or imprisonment for a period not exceeding 3 years, or to both a fine and imprisonment. We recommend that the sentence be revised and read as follows: is guilty of an offense and is liable on conviction to a fine or imprisonment for a period determined by the court based on the culpability of the offense committed. The offense, our response is that the offense is identified clearly in the bill. It is the usage of the name of the council without authorization, and there is no need for the court to determine the culpability of the offense. However, the court can still decide. So I think at the end of the day, we will leave it as it is. The next question 3 is from South African Amnesty International. The narrow definition of civil society. The current definition of civil society reads as follows: civil society includes non-governmental organizations, labor, and structures or institutions that represent the interest of citizens in the field of gender-based violence and femicide. Deeply concerned, however, is this definition's focus on citizens. Gender-based violence affects all those who live in South Africa, including refugees, asylum seekers, and undocumented persons, and the country constitution protects the rights of all people. The usage of the word citizens in the definition may have the effect of excluding structures or institutions representing the interest of non-citizens who reside in South Africa and are also affected by gender-based violence and femicide. According to the bill, civil society includes non-governmental organizations, labor structures, or institutions that represent the interest of citizens in the field of gender-based violence. It says includes, it doesn't exclude, it includes over and above governmental organizations, labor, and structures or institutions that represent citizens in the field of gender-based violence. The department was amenable to align this clause to section 7.1 of the Constitution. However, the Portfolio Committee indicated that it is satisfied with the current definition. The next question is the definition of femicide. The current definition reads as follows: femicide means the killing of a female person or a person on the basis of gender identity as a female, whether committed by a person within domestic relationship, interpersonal relationship, or by any other person. The definition of femicide is in line with the definition of the National Strategic Plan on Gender-Based Violence, the founding document of the bill. The NSP was the one that defined the femicide. So we took that definition. The next one, recommended definition of femicide means the killing of a woman, CIS or trans, because of their gender or gender identity, whether committed by a person within a domestic relationship, interpersonal relationship, or by any other. They are repeating what we had said then. Definition of gender-based violence. Gender-based violence means violence associated with gender, which includes physical, sexual, verbal, emotional, economic, educational, or psychological abuse or threats of such acts of abuse in public or private life. By broadly defining gender-based violence to that which is associated with gender, the definition may in fact overlook the nuances of violence directed at those who depart from traditional gender norms. Our response is that the definition of gender-based violence is in line with the definition as provided in the National Strategic Plan on Gender-Based Violence and the Domestic Violence Act. The next one, their recommended definition, we've already responded to that we took the one on the NSP. Their recommendation was gender-based violence means any harmful act against a person or group of people or which disproportionately affects them because of their gender, sexual orientation, or gender identity or expression. Such violence includes physical, sexual, emotional, economic, educational, or psychological. This definition is also included in the Domestic Violence Act as indicated that we took the NSP definition and the one on Domestic Violence Act. Next page, lack of clarity regarding the council's relationship with key stakeholders and accountability mechanisms. This was also raised by Sonke Gender Justice, we responded to that under clause 5 to indicate that it provides that in order to achieve the purpose of the act, the council must ensure coordination between all structures established in terms of this act in matters relating to the implementation of the National Strategic Plan. So we had already responded to that. Can we go to the next page under tagging? Question 4, call to action, Sonke Gender Justice, I pass South Africa. The tagging, we had already indicated that the state law advisor insisted that it's a section 5, and also the portfolio committee insisted that is section 5, and also the joint tagging mechanism committee in Parliament concurred with that. So I'm going to skip that and go to the next one. Clause 1. Also, clause 1, we've indicated that the bill does not talk to interministerial because it's the president's prerogative to establish an IMC. Clause 3, the first provision of clause 3 states that the National Council on Gender-Based Violence has hereby been established, yet there are no preceding clauses that stipulate explicitly in what manner it is constituted. There needs to be a clear articulation of various role players and lamentation of their different positions, including their duties and responsibilities. Clause 3, subsection 3 provides that the council acts through its board. Subsequently, clause 6 provides for the appointment of board members, whereas clause 15 provides that the board must appoint the chief executive officer, who is the head of the secretariat of the council, which is responsible for the day-to-day operation of the council. The composition of the council is as provided for in the National Strategic Plan on Gender-Based Violence and Femicide, paragraphs 5.4, 5.41, and 5.42, under pages 58 and 59. Clause 5, the functions of the council cannot be clearly defined in the structures of the council itself, is not explicitly included in the bill. It is, in fact, my apology, the function of the council cannot be clearly defined in structures of the council itself, is not explicitly included in the bill. It is, in fact, for this reason that it is crucial that the bill be tagged as a Section 76 bill instead of Section 75. The NSP on gender-based violence and femicide has specifically allocated functions to provinces and local municipalities, which are administrative in nature. Our response is that clause 5 of the bill responds to that. Paragraph A provides that the council must develop an action plan not later than 6 months after its establishment for the implementation of the national strategy addressing gender-based violence and femicide, which must, 1, be adequately costed and implemented effectively. 2, set indicators and timelines to be complied with by all relevant stakeholders. And 3, coordinate the monitoring and evaluation of the implementation of the national strategy addressing gender-based violence and femicide. B, coordinate measures for education and training concerning the prevention and combating of gender-based violence and femicide. C, ensure coordination between all structures established in terms of this act in matters relating to the implementation of the national strategy addressing gender-based violence and femicide. C, facilitate strategic partnerships between the council and relevant stakeholders as and when required. E, in consultation with the minister, facilitate the establishment of intersectoral and multi-sectoral structures to jointly prevent and respond to gender-based violence and femicide. And F, coordinate the prioritization of gender-based violence and femicide programs at national, provincial, and local levels and at community and other forums. 2, the council must advise the minister on any developments relating to the prevention of and response to gender-based violence and femicide, relevant international standards to be adhered to, and see any matter falling within the purpose of the Act. 3, the council must report to the minister at least 4 times a year on its activities, the performance of its functions, and the achievement of its objectives. And the minister must cause such report to be tabled in Parliament as required, provided that the council may at any time submit any other report if it is deemed necessary by Parliament. The council must review the strategic action plan and as identified by the minister every 5 years or as required after the date of its commencement. I think we have responded to that question.
DG, can I interrupt you?
Yes.
Can I interrupt you, DG? My apology to the members and the minister also. I've just been informed that there's a serious technical problem, meaning we will be kicked out again within 10 minutes, and then we'll have to rejoin again in a new link. I'm just informing so that we know what will be happening here. But our apologies for that. DG, you may continue.
Thank you very much. Clause 6.1. Can go to clause 6.1. I'm not going to repeat this one because we've already responded to that earlier on, that the 80% has been removed. So I'll skip clause 6.1. I'll go to clause 6.2. Clause 6.2 says, on the appointment of civil society representation on the board should be in line with the NSP, which states that 7 representatives from civil society will be appointed through a process of public nomination. The public nomination will be overseen by the presidency through the Minister of Women, Youth and Persons with Disabilities, supported by the technical team. This is not correct. From the beginning, it was going to be Parliament that was going to appoint, and Parliament increased the number for government from 6 to 8. That was the Portfolio Committee on Women that increased the numbers. Clause 6.6, the bill states that the minister must appoint members for these positions. We submit that this should be amended. Our response is that clause 6.3 provides that the president must, whenever necessary, to appoint members of the board referred to in subsection 1A, make an appointment from the list of persons recommended by the National Assembly by way of resolution with a supporting vote of the majority of the members. This refers to if another member has when there's a vacancy at the council, the National Assembly will always recommend more numbers. Rather than 15, they may recommend 18, so that if there's a need, the president can appoint to fill the vacant post from the numbers that have already been given, from the 3 that would be remaining after the appointment of the 15. According to next page, according to clause 6.5, the president must ensure that the positions of chairpersons are held alternatively by a representative from civil society and the organs of state. So it would be a alternative representation. If the chairperson is from government, then the deputy chairperson will be from civil society. We'll go to accountability, reporting, and transparency. Persons consulted. In the memorandum, reference is made to the consultations and opportunities for South Africans and stakeholders to make inputs to the bill. However, it is our submission to the Portfolio Committee that inputs and consultation resolutions referred to in this clause have not been considered appropriately, or appropriately considered. I think this was sent to the Portfolio Committee. It's copy and paste. They're sending it here. And I believe that the Portfolio Committee did give people who raised the issue that they were not consulted and indicated that we're giving you up to next week, make inputs. However, those people didn't make inputs. The department submitted to our response here is that the department submitted to the Portfolio Committee the attendance registers for public consultations that